Morning viewers, welcome to Consumer Shorthand classes. 5 seconds, start. We would therefore direct the Registrar, Appellate Site, the High Court of Judicature at Bombay to take steps in implementing the following directions immediately. 1. Every petition, application under Articles 226 and 227 of the Constitution of India should be styled as civil writ petition or criminal writ petition as the case may be. 2. Every petition, application under Articles 226 or 227 of the Constitution of India presented through the Council or where such petition or application is presented in person should be accompanied by the certificate of the Council or petitioner in person, as the case may be, that such petition or application is criminal writ petition or civil writ petition. 3. The registry should examine such writ petition filed under Articles 226 and 227 of the Constitution of India, styled as civil writ petition or criminal writ petition, by finding out the nature of the relief bar reliefs claimed in such writ petition and the grounds of such relief bar reliefs, and if the registry finds that the writ petition has been wrongly styled, such objection must be raised. 4. Civil writ petitions should be registered by the office in the separate register under the title Civil Writ Petitions under Articles 226 and 227 of the Constitution of India. Special civil applications occurring in Clause 6 of Rule 10 of Chapter 5 of Appellate Side Rules be read as civil writ petitions. This is so done to continue with the existing practice since 1980. 5. Criminal writ petitions should be registered under the separate head in register maintained by the office bearing the title Applications under the Constitution under Chapter 26, Rule 4-6 of Appellate Side Rules. The objections raised by Mr. Manohar in the present writ petition may be examined now in the light of the discussion made herein above. A look at the reliefs sought for by the petitioner would show that the petitioner seeks to enforce his fundamental right under Article 19(1)(g) of the Constitution of India and his other civil rights. The petitioner has sought a writ of mandamus or any other appropriate writ, order, or direction, seeking declaration that the first respondent, its servants, agents, or officers are not entitled to cause any interference or obstructions or to take any steps to cause any interference or obstruction to the members of the petitioner association and like operators to carry out their lawful business of receiving signals through the satellite channels and in turn render their services to respective members and TV set holders. Petitioner has also sought for a writ of mandamus or any other appropriate writ, order, or direction restraining the first respondent, its servants, agents, or officers, or anyone claiming through or under him by a permanent order of injunction from raiding or from seizing any equipment enlisted in annexure to the petition from the control rooms of the members and the like apparatus and or causing any obstruction and or interference or to take any steps to cause any obstruction and or interference in carrying out their regular business as lawful cable operators by receiving signals from satellite and in turn render services to its various members and TV set holders in any manner whatsoever. Obviously, the petitioner is seeking a relief which otherwise largely could be claimed by it under Section 60 of the Copyright Act 1957, which provides that any person claiming to be the owner of copyright in any work by circulars, advertisements, or otherwise threatens any other person with any legal proceedings or liability in respect of an alleged infringement of the copyright, any person aggrieved thereby may institute a declaratory suit that the alleged infringement to which the threats related was not in fact an infringement of any legal rights of the person making such threats and may also in any such suit obtain an injunction against the continuance of such threat and recover such damages, if any, as he has sustained by reason of such threats. It is thus clear that by this writ petition, the petitioner is seeking to enforce his civil rights and therefore the present proceedings are in the nature of civil proceedings. Even the learned counsel for petitioner concluded that it would not be possible for him to justify the nature of the present proceedings as criminal writ petition. The question arises that though the present writ petition is of the nature of civil proceedings, the petitioner has filed the present writ petition as criminal writ petition, and in this view of the matter, after holding that the present criminal writ petition is not properly styled and maintainable as such, whether this criminal writ petition should be rejected at its threshold or not. The procedure is always handmaid of justice and not its master, and because of the mistake committed by the counsel in filing the present criminal writ petition, the litigant should not be allowed to suffer, and in our view, interest of justice would be met if the petitioner is permitted to convert this criminal writ petition as a civil writ petition and place it before the appropriate bench for consideration. Order accordingly.